On today's show, we're going to explore a key stakeholder role in the incident commander ecosystem, which is your legal team. During major incidents, your legal counsel is usually one of the key primary stakeholders that often need to be called right at the start of an incident. To better understand what role legal generally performs and why it is so important to bring them early in the game, I could not have found a better guest candidate than Jonathan Armstrong. Jonathan currently works as a partner at Punter Safal Law, and one of his main endeavors is to help organizations with legal and compliance issues across Europe. So, often when we talk about lawyers and legal, a lot of individuals will identify legal as being people that show up somewhere later after an attack has occurred, when potentially some lawsuits are coming in from customers or partners or stakeholders. But how do you see, as it stands today, the role of legal in a major incident, such as, for example, a ransomware attack?
Yeah, I think it's a really great question. And I think it probably has changed a bit, but some things are maybe constant. And I've probably been doing data security work for about 30 years, and I think you have
Oh.
seen changes.
Hmm.
One of the changes you've seen has been the rise in litigation, the rise in people trying to get something out of a breach. And I think maybe a good lawyer maybe brings, say, 8 different things to the table. I think the first is privilege. That's really important in the days of aggressive litigation, in the days of aggressive subject access requests, because it is sometimes possible to keep hold of some information if it's been obtained under privileged situations, and privilege is a very complicated topic. I think, secondly, lawyers who've been around the block a bit, and I'd put myself in that category, can sometimes offer wise counsel. I think, thirdly, sometimes, oddly, if a lawyer's experienced in this area, they sometimes give you a chance to breathe. I think we underestimate the psychological and emotional aspects of data breaches. So, just to give you an example of that, I have done work for one US corporation for almost 30 years around data security for them. And I get quite a lot of leeway as a result. And sometimes I'll do the first call with the vendors. And we had a vendor data breach, a medium sized vendor. And the CEO personally took the call, and he went through what he'd done. And I said, look, whatever happens, I can't prejudge what we're going to do and how this all plays out. But I just want to take a moment to say, I think you've acted pretty responsibly. The fact that you're the CEO and you've attended the call and fronted up is a positive for us. And I also appreciate the emotional roller coaster that you're on. You've done a lot of work in the first 30 odd hours of the breach. I know you've probably been up overnight. I know you're probably not sleeping. And just human to human, I want to say I understand that. And he broke down crying and, had to pause the call. And I think sometimes we don't understand that emotional aspect of a data breach. And I think a good lawyer who's been there a number of times can often provide that ability to breathe, if you like, and that sort of element of, you're going to get through this and focus. Maybe the fourth thing is knowing what the market looks like. So for some organizations, they might have no experience of one particular threat actor. Obviously, the incident commander might bring that experience, but sometimes lawyers do. Again, because we sit in that privileged tent
Mhm.
on different breaches. So sometimes we know stuff that isn't out there in the market about how particular episodes have panned out. And of course, only a very small amount of ransomware attacks get into the public domain. So we often see stuff that other people don't know about. I think, fifthly, sometimes we've come across threat actors before, so we'll know who they are, what they do, how they might be likely to behave. I think we're increasingly going to see that as become very relevant, because I think we're going to get like almost fake threat actors appear who
True.
either haven't been responsible for the original breach, or they're just pretending. And I think we're starting to see some of that. I've certainly seen for which there was a fix available because they were using old tools. So I think there's a sense check there. I mean, obviously, the interface with regulators is generally led by lawyers. So again, I like to be there at the very start because then I can explain that whole process to regulators. We've talked about the threat of litigation. Every good incident should have an eye on that litigation. It's an aligned process. It's not a sequential process.
Mhm.
What you do in the first 24 hours of a breach will affect your ability to defend litigation that results. And then maybe eighth is, it's a bit of an odd thing to say, but sort of muscle reputation, particularly important with vendors. If you have your payroll vendor breached or your HR system, you will be one of about 100 or 150 or 200. Your ability to extricate yourself with the minimum litigation risk, the minimum reputation risk, the minimum regulatory risk will depend oftentimes on how much information you can get out of the vendor versus how much information the other 150 customers can get out of that vendor. And if you've got a lawyer that the vendor recognizes or looks up their LinkedIn profile
Mhm.
and thinks, he's going to be a bit tough, then I think you get more information out of that vendor and you get treated with a bit more respect. So there are probably more than 8 reasons, but they're certainly those that comes to my mind
So a lot
immediately.
of the organizations that I work with today, so I'm writing incident response plans, I am writing playbooks for different incident types. And what I noticed is the, I would say, foundational knowledge of bringing in legal early in an incident still isn't anchored in the muscle memory, as you were mentioning on the previous question. And things are not baked in of bringing in legal early to avoid trouble downstream, really, on one side. And on the other side, the number of regulations are increasing, making things a lot more complex when it comes to
Yeah.
timelines, and especially when you're dealing with cross-border investigations. How would you encourage organizations to be better prepared for this, even faster evolving threat landscape on one side, but also, the growing complexity when it comes to regulations?
I think you need to get your lawyers involved and you need to build that into your muscle memory, as you say. And for most organizations, they don't rehearse incidents enough. And when they do rehearse incidents, they don't rehearse them with their lawyer. And as a result, the the game plan goes out of the window and they're all very surprised by that. Oftentimes it is a timing thing, like you say. You might have 72 hours before you've got to speak to a regulator. For some people, it might be 24 hours. For some people, you might get less time, particularly if the press has got hold of it,
Mhm.
or you've got a victim who's kicking up a fuss, particularly when it's employee related. Employees, surprise, surprise,
Mhm.
tend to react pretty badly when their bank details are leaked online, for example. So, so the time has definitely changed in the last 30 years or so. You used to have longer to deal with incidents as a general rule. That isn't just legislative change. Obviously, the 72-hour deadline came in 2018 for most organizations. But it isn't just regulation, it's the fact that the pace of change, with the internet, with different news sources, with specialist blogs, with people trawling the dark web, you have to be able to respond more quickly. So as a result, you've got to rehearse these things
Mhm.
more. You've got to rehearse better. you've got to rehearse with your lawyers. And you've also sometimes got to look at the obvious. So, for example, one incident I know one of your colleagues helped us with, we had a client that had a playbook, but the ransomware attack closed down their system and the playbook was on the system. I'm a big fan for saying, organizations should have like a hard copy red folder at home
Mhm.
that has the plan in. In that particular breach, we 7:30 in the morning, we're going through the Instagram photos of the head of HR because we're trying to work out who had been at her wedding. And we're trying to recognize, or the business is trying to recognize somebody from the wedding pictures
Mhm.
on the basis that if they were at her wedding, they've probably got her mobile number because nobody else has got her mobile number saved onto their phone. And we got a result in the end, bizarrely, through through the through blowing up Instagram photos. But trust me, there's a better way than trying to do that at 7:30 in the morning. And that better way is often having hard copy escalation trees for who you've got to call, having hard copies of the plan, but
Mhm.
most importantly, rehearsing as close as you can to a live scenario to get that muscle memory and to get everybody know their roles and responsibilities.
So I don't know about you, but the customers that I'm dealing with are still at the point, for example, that even if legal is mentioned, very often I find that legal is not reachable over the weekend because legal is not considered a 24 by 7 partner of the ecosystem. Well, they should be. And as you mentioned, if you've
Correct.
not practiced this, so it's one thing to mention legal needs to be involved as part of the incident response plan. It's another thing understanding, well, how do I get hold of legal during the weekend and what are they expecting out of me? So that two-way communication can only be gained with testing. I think a lot of organizations struggle bringing some of these external partners into these exercises specifically. The same goes with MSSPs. We often
Yeah.
push our customers to say, test your SOC, test your MSSP, bring them into the exercise. And very often we're confronted with the MSSP saying, well, I can't share the procedure with you. It's proprietary information. I'm like, well, I can't test you if you don't tell me what you're going to be doing. There's a lot of work to be done to even come close to the expectations that the regulators are expecting from us, which is
Mm-hmm.
almost like as soon as you become aware of a potential incident, bring it up to the regulator, even though you're not sure yet. And obviously there's a delay between when you get the first alert versus understanding what data was taken potentially. And people clearly are scared of coming out with, we had a potential breach, and therefore they wait until it's actually sometimes too late.
Lots of really good points there to unpack. I think, first of all, yes, you do need to know who your lawyer's going to be. So, for example, I've done a lot of work over the years with chemical companies.
Mhm.
They're pretty good at, asking you for multiple ways to contact you, and they follow that same, if the plant blows up, we're going to need you. So how do we contact you? Um, some people, I mean, it's a preference thing, isn't it? Some people have lawyers on retainer and they pay them an annual fee for that. Uh, Being blunt, for my good clients, I don't do that, but they will have my home number, they'll have my mobile number, they'll have a team sheet with other people in the team if they can't get hold of me. So, first of all, yes, you need to do that in advance. Secondly, in some jurisdictions, it's still difficult. I did a breach where we needed Italian lawyers on a Friday evening in August, but we also needed sober Italian lawyers on a Friday in August. I think it was call 7 before we got what we wanted. Even with the contact list that we have, sometimes it's a bit hairy getting people in that timeline that you want. So I think you have got to plan in advance. And I think as far as what to tell regulators and when is concerned, then regulators are somewhat realistic. They don't expect you to have all of the answers immediately, but they expect you to make a best endeavor to tell them what you can tell them. And again, for a lot of organizations, the invest in the system to do that. We know the information that regulators are likely to want, and we know when they're likely to want it. So we will usually prepare like a capture form with the client to say, when you hear of an incident, if even if that's as trivial as an employee rings you to say they've left their laptop on a train,
Mhm.
here are the questions we're likely going to be asked by the regulator. So let's capture them very early in the process. And if we don't know the answers, let's structure our incident response to getting answers to those questions, as well as the other things we're doing, stopping bad things happening, stopping exfiltration, whatever that is. We need to collect answers to those questions as we're going. And the more people know what those questions are and they're familiar with them, then the easier it is to report to regulators. And then again, it's a sequential process, isn't it? You have, generally speaking, an obligation to report to a regulator. Usually, for most people, 36 hours, can be 24. But again, they're quite realistic. Tell them what you can tell them honestly.
Mhm.
Don't guess at stuff if you don't know the answer. And don't undersell the problem. If you genuinely think 4,500 people are affected, don't say to the regulator, we can only trace the records of 30 people. That's not honest, and that's going to store up problems for later on. If you think it's 3,500, say 3,500. Tell the regulator what you know and what you don't know. Um, and it's, back to the old, US military thing of knowns and known unknowns. Be honest with regulators, share it with them, and in some cases, ask them for help as well.
Mhm.
If you've engaged with a vendor, for example, and the vendor's caused the breach, and the vendor isn't giving you any information, it might be that you can ask the regulator to knock on their door,
Mhm.
and you might get information that way.
I guess there's still this natural fear of reaching out to an external party. It requires a change in the industry of a mindset, I think. Being more proactive is going to be the only choice with the timelines of
Correct.
reporting going down. And, I was doing a tabletop exercise not too long ago with a financial institution in the Middle East, doing business in multiple countries. And so they were dealing with different data privacy laws, one of which said you need to notify as soon as you become aware. The other one was within 24 hours. The other one said 72 hours. And then banking authorities have their own reporting authorities to report to the national bodies in those countries, which makes it extremely complex, in my opinion. The second part, which I think is important, and comes back to exercising, is creating, a form of pre-established communication template with each other. First
Mm,
of all, with your stakeholders, but also, how are you going to communicate to the regulator? How are you going to communicate to your internal users? Because you need to reassure them, as you said, the employees generally get very nervous if their data is basically being leaked. And so I think there's a lot of way to go still. I mean, we're making progress,
yeah.
forced by regulations for sure, but in practice, I see that a lot of organizations are not there yet for the real thing.
Yeah, I mean, there's some really good points there as well. I mean, first of all, I don't think you don't control whether a regulator gets involved or not. You control whether you tell them or
Mhm.
whether they ask you.
Mhm.
So you've got to look at that inevitability in a big breach that a regulator is going to ask you questions. And if a regulator doesn't ask you questions, then a customer is or an employee is. You've got to think carefully about the communications and not necessarily be guided by legal obligations. So, to give you one example, I dealt with one of the earliest biggest payroll breaches for a US corporation. They decided, this is pre-GDPR, they had an obligation to tell US employees, but they didn't have an obligation to tell employees in the EU. So they took the decision to tell US only, not EU. Of course, within less than an hour, the EU employees knew as well, because they'd been on a call with colleagues who'd said, how do you feel about the payroll leak? They'd said, we don't know about it. It's a much worse problem when employees find out from each other than if the employer tells them. So they made a bad situation materially worse by withholding information because they felt they didn't have a legal obligation. And so oftentimes we'll report early in some jurisdictions. I had one with obligations to report in the US, obligations to report the UK, EU, and Australia. And the Australian reporting obligations weren't as tight, but we still took the view that we'd report early there because we'd rather that regulators cooperate, regulators meet each other, they share notes. We'd rather be telling all of the regulators our story than have somebody else repeat it secondhand and the regulator be annoyed about that. So how you communicate is important and what you communicate is important. And I agree with you about pre-planning communications. I often talk to clients about what I call resetting the default settings in communications plans. So for any organization of any size, a data breach is inevitable. Once you've decided it's inevitable, instead of saying, should we prepare? It's obvious that you should prepare. So how do you prepare? Well, one of the things that's the biggest slowdown in telling stakeholders is getting people to agree a press release or getting people to agree communications. Because people are in a panic, because they know that the business likely has made some bad decisions, they're scared of making any other decisions. So the default setting for some people is to move commas around a sheet of paper because they can think in their mind that they're doing something, but without making a material decision. So I think what you need to say is, this is the press release that's going to go. This press release is going to go within an hour of the breach, or you set your own timing, unless anybody comes up with a meaningful reason why it shouldn't go. And then you get people to focus their minds on material things rather than commas. Because if you ask for consent in a crisis, you don't get it, and you store up a world of pain. And that's why people report breaches late. That's why they bury their heads in the sand. And I think that's also partly why probably more than 50% of breaches are reported on a Friday afternoon going into evening, because people delay, then they run out of time and they've got this mental thing that they have to have a clean desk on a Friday. So only then do they decide to reach out to regulators. So you have to prepare. And as I say, breaches are inevitable. The only thing you can control is how well you respond.
What does it mean to put a case under legal privilege?
I think that's a simple question with a very complicated answer. I mean, I think in most cases you'll want to preserve privilege, as I said, in part because you've got to deal with the incident and also look at the regulatory and litigation fallout at the same time. And I think you've always got to assume the worst. Privilege is a really complicated topic. I know in 2007, the firm I was at the time, we tried to get together privilege in one place, and we looked at different jurisdictions and where it lived in professional codes or whatever. And even then it can become complicated. If the European Commission leads an investigation versus if it's domestic authorities, etc., etc., etc. So it's a very complicated topic. But as a general rule, you can't retrofit privilege. So you need that from the very start. So that's why lawyers will obsess about who was instructing who, under whose direction they're working. We'll sometimes look at seconding individuals from the organization to the investigation to help create the report, and we'll look at who we're reporting to and what we're reporting.
Mhm.
Privilege is under attack, not only by regulators, but also by litigants. And you have to look at the purpose of the work you're doing. So, for example, we've had some big litigation in Australia over the Optus telco breach, where they tried to construct the report from the incident response team under privilege. But then the CEO was interviewed on TV, and she talked about the report and said it's going to give us learnings for how we do business going forward, or some words like that.
Mhm.
And the court subsequently decided, well, that waived privilege. There was, even if it was for litigation purposes, originally, you sort of added another purpose. We've had cases in the US with a law firm who's quite experienced in this space, but they didn't control the content of that privilege stream and looked into other areas of the business, which again eroded privilege. So the first letter you get whenever there's a hint of litigation nearly always asks for the incident report, asks for details of the breach and the response. And you only really can resist that by being able to say it was created under terms of privilege. And of course, those requests are much, much more common
Mhm.
in an era where subject access requests are rising. Often, class action lawyers are using subject access requests as a cheap way of trying to get pre-action discovery. And why they're doing that is they're trying to build a case to sell it. So if they can get this much information
Mhm.
for free, they can put that as a package together, go to litigation funders, and sell the litigation. And once it's in the hands of litigation funders, it's very hard to get rid of that claim. Your best opportunity is to look at the information that you're controlling, and then you're perhaps in a position to defend yourself. So privilege is always going to be very, very important. It's always going to be something that your lawyers are going to agonize over. You can never guarantee that privilege will work because of those jurisdictional complexities that you've said, and because of the way in which organizations and their subcontractors and vendors and investigators behave. But just because you might not succeed doesn't mean to say you shouldn't try.
How come legal sometimes advises you to not put anything in writing?
It gets back to that whole bit about the plan should be realistic, and you should be including your lawyers in the creation of that plan and in rehearsals. Why we often don't want stuff put in writing is, particularly in the early hours of a breach, my experience is people speculate, and they often speculate wrongly. In some respects, uh, individuals under crisis behave a bit like Gen AI can.
Mm.
They fill vacuums with answers, even if they don't know the answer. Quite often, also, we get the attack vector wrong initially. So we might think it's purely external, but there's been internal help. We might think it's a vendor problem, but it's an us problem. We might think that, I don't know, that MFA has been bypassed, but actually it turns out that an employee was responsible for the compromise. Whatever that might be,
Mm.
we often get things wrong. And if we document our wrong turns, then that can come back to haunt us. It makes us look disorganized.
What are your thoughts that ransomware negotiations now are available on the clear web on sites like ransomware.live?
Yeah, I think it's a really interesting topic. And I've also seen ransomware gangs release the dialogue as well, particularly to try and embarrass uh, the organization they've compromised, and again to try and extract uh, money from them by threatening to leak the chat, then leaking a portion of it. I think negotiating with ransomware gangs is a fraught area. Being candid, I've not done it. I probably would never do it. I'm not sure it's the right thing for lawyers to get involved with. I think we're increasingly seeing, um, well, I mean, so to take a step back, attribution's always difficult.
Mhm.
So in the first phases of an incident, you don't know who you're dealing with. Are you dealing with, um, some communal garden crime gang? As I said, are you dealing with people who are secondary buyers of the data, or are you dealing with the North Korean state? So you don't really know who you're dealing with. And as a result, we've seen increasingly the overlap of sanctions law with ransomware payments. And I was at a conference, the CISO 360 conference in Edinburgh yesterday, talking with somebody who's just come out of UK government, where they're looking again at penalizing people who pay ransoms. As I say, the sanctions regime, the US and the UK particularly, have used that to sanction ransomware threat actors, mixers, people involved in the crypto um, demand chain, as well as to sanction states like North Korea. And I think we can expect that to increase. So obviously, those conversations are going to be embarrassing if you're talking, whether intentionally or not, about breaching sanctions law by making a payment. Whether or not you intended to make the payment, I think that's a dangerous world. So I think, as a general rule, most organizations are moving to a default position that they won't pay ransomware. I think that's probably the right position. And I think I've seen a change in that in the last 3 or 4 years. But I know that people are, like you say, trying to buy time by pretending to negotiate with threat actors. And again, I think that's something that you have to be very careful about, because, as you said, the likelihood is increasing of those chats being um, coming back to haunt you. And again, the other thing we have to bear in mind, I think, is the whole ecosystem around a breach. That, as well as knowing your lawyers, it's probably a good idea to invest time getting to know your insurers as well. Because if you have cyber insurance, you might not have choice over the negotiating stance unless you've agreed that in advance. And you might not have a choice over the providers that your insurers are using unless you've talked about that in advance. And some insurers are using third parties to commence negotiations,
Mhm.
and you just need to be careful about that, because it won't have the insurer's name on those chats. You'll be associated with that, even if you didn't know what was going on and you didn't sanction what was going on. So I think, again, it's one of those issues where prepare now for that, have a playbook, make sure that your lawyers have looked at it, and also make sure that your insurers know the way you want to do business.
What are your thoughts on engaging with law enforcement?
My recent experiences have almost always been positive. I think they've, generally speaking, been good resources, and obviously there's a lot of almost micro specialism between the larger law enforcement agencies as well. You might get UK police or FBI team that are just looking at a particular threat actor,
Mhm.
and they've got some very useful intelligence to share, and have resources that you don't have, and are useful. And then regulators also like that as well.
Mm.
If you're going to report a breach to a data protection regulator, most of them will ask you, are you involving law enforcement? Yes or no? And I always think that you're probably scoring more points if you can tick the yes box.
What are your thoughts on paying the ransom?
I think there are cases when you'll want to consider that. And I think the last time I spoke to law enforcement in a live incident like that, they were aware that that might happen.
Mm.
In some cases, law enforcement will support a payment being made, but they would like to be involved. And there's all sorts of reasons for that. And I think we probably have seen the takedown of some ransomware threat actors when payments have been made, sort of in the same way that conventional ransom money might be paid with numbered notes. Then obviously, if payments are made, then law enforcement might want the opportunity to decide how those payments are made, etc. But I think you make a really good point about you don't get money back guarantees from threat actors. And also, organizations don't, a lot of boards, from my experience, think that if you pay the ransom, you're up and running again within an hour. That's almost never, ever the case.
No.
I nearly always, whenever I have a board that says that, I need to always send them the report of the, it's a bit old now, 2021 HSE incident in Ireland, where they're given the decryption key. They have, I think, 1,200 military reservists who supplement the IT team, and it still takes them whatever it takes them 9 months, I think, to get up and running on 70% of the estate or whatever the figure is. This isn't a pay the money, switch the lights back on situation. There's nearly always a huge impact on the business, even if they cough up and pay the ransom. So sometimes businesses, I think you're right that in a few edge cases, it might be that the ransom has to be paid. But I think in the majority, the board or senior executives are pushing for a ransom to be paid because they don't understand that that doesn't mean that they're up and running again in an hour. So sometimes that's an education piece as well, and walking the board through so that they can make educated choices. And in my experience, when you do that with most boards, they decide that paying the ransom isn't the right thing. I think if you pay once, expect to pay again. You go on a suckers list. You get a reputation as somebody who will pay. I think my suspicion is that some organizations who paid ransomware once regret it because they know that that's not the end of the story. Like you say, they've maybe got a decryption key that doesn't work. They've got difficulties if they go and then ask law enforcement for help. In some cases, I have seen cases where people in government have known more about the ransomware than the organization itself. If the data eventually does get on the dark web and you've paid a ransom, you just add to the embarrassment of those discussions. And again, if you're going to do it, I'd want some intelligence first. I mean, obviously, this isn't a look for Sophos, but people like Don Smith, your colleague. I'd want somebody like that to tell me a bit about the threat actors, the chances of getting paid, who they're affiliated with, etc., etc. Yeah, and these groups are fighting each other and splintering as well. So if if the group that's attacked you is for the sake of argument, a loose association of 8 people, and you pay a ransom to guy one, well, and he doesn't give the other seven guys a cut,
Mm.
then they're going to come back at you as well. They're certainly not going to give you decryption keys. They're not going to sign some sort of legal document to say they will never leak the data again.
Mhm.
You have no certainty. And I know some people say that a lot of ransomware gangs, behave like people of honor because it's their business model. But I think that's a bit old fashioned. I mean, it's not like, we're not in some Johnny Depp film. These aren't,
They're bad
pirates
guys.
with an honor code.
They're bad
Yeah.
guys. There's no honor code. Third-party vendor challenges.
I suppose partly the dull legal answer is the contract. So you've got to make sure that your contract's fit for purpose, not only so that you have rights in a breach, but also so that you can show that contract to a regulator and say we did the best we can. And I think from a regulatory point of view, that becomes a challenge for an organization as well. Firstly, because you often can't get information out of the vendor that you need. And secondly, because I think some regulators are looking at data breach notification almost like the Olympics, like a competitive sport.
Mm-hmm.
If I've got 100 people affected by one vendor's breach, who tells me the quickest, and who tells me stuff I don't already know?
Mm-hmm.
So whenever we're dealing with vendor breaches, we're quite often trying to get information out of the vendor, and we're also doing our independent analysis of that incident. So to give you an example of one that's live, so I won't give you much details, we know that there are dark web posts that other people have seen, other customers of this vendor, but we've just found a Chinese language dark web post that we don't think anyone else has seen. So obviously we're showing that to the regulator because we want the regulator to think that we're being more assiduous than anybody else. Now, vendors have different approaches. As I've said, we spoke already about a very good vendor who put the CEO up for interview. I've just had another one recently where we got to speak to the team lead personally. He offered us half an hour in the middle of a crisis, gave us an hour, was open and honest with us.
Mm-hmm.
Now, obviously, we're more relaxed about that. And we're also probably going to reflect that in our regulatory response as well. But equally, if we have vendors that sit on information or refuse to cooperate, then that reflects in what we tell regulators and how we behave. We've just settled a case. So actions against vendors post breach are still relatively rare in my experience, but we just settled one where my client, we were quick out of the blocks. It's a breach that affects many different organizations.
Mm-hmm.
We were, I would have thought we're within an hour of the breach happening. So I would have thought we're first in the race. The vendor didn't really give us much information. Mm-hmm. We had a contractual right to information, which the vendor just said, so what? We had audit rights, so we said we were going to turn up at the premises, and the vendor threatened to arrest us. And so we've obviously then threatened court proceedings against them, and either the vendor or their insurers, I suspect the insurers, have just paid us, a sum of money mm-hmm. to settle those pleadings. One of the funniest I had is a large, well-known vendor who, again, wouldn't give proper information about the incident. Mm-hmm. It was a breach that affected a lot of our clients' employees. They thought there was a potential for identity theft. They thought they owed it to their employees to get answers. And at the same time, they, from a regulatory point of view, thought they had to get answers. And I said to the client, the only way we can escalate this is, I think, to go along to their premises where the breach occurred, which happened to be in Barcelona, and just exercise our audit rights. There's no notice provision in the audit. We can just literally show up, audit, and let's question people. We turned up in really smart suits. The client said, look, what's the downside? They bar us entry. We'll go and eat in some nice restaurants in Barcelona and come home. We showed up at their premises, as I say, smart suits, laptops, etc. They said they couldn't possibly let us in, that they had to security clear anybody to come into the facility, and that they thought it would take 3 weeks, I think they said, for the security clearance to come through. So the client and I just said, that's fine. You've got a nice big reception. We'll just set up shop here. Tell us when you're ready. So we opened our laptops, we moved some tables around. We sat there as if we were going to work from there for however many days it took for them to give us access. And I think that they managed to do it, I think, in 12 minutes.
Wow.
So they managed to do the entire, because obviously they're trying to sell from that premises. The last thing they want is to explain why there's a couple of lawyers who set up office in part of their reception. So sometimes you have to go to relatively extreme measures. Of course, we got a very quick closure from the regulator because we had gone to those lengths. They let us in, and they ended up refunding they gave our client credits back to refund the cost of the investigation. So I think sometimes there's a particular issue with vendor breaches, but you've got to regard it as a competitive sport. And you can't just think, because the vendor isn't telling me anything, I don't have an obligation to regulators, I don't have an obligation to employees, I don't have an obligation to customers. So you need to tighten up on vendor onboarding, third-party audits, you've got to dig behind them. And the other thing I'd say that's particularly relevant at the moment is when I started writing software code when I was a kid, you would never ever change the code. But in the sort of AI OpenClaw type era, a lot of software is changing, if not minute by minute, then day by day. And so obviously your vendor's code is changing as well. And that's exposing vulnerabilities that didn't exist in the world where, software was one and done. So you can't have that sort of, we'll look at the vendor once and never again, because they're not only changing their code, they're changing their business model. Vendors who are recruiting on your behalf are almost certainly using AI-enabled applications that they weren't using 5 years ago. If you signed that contract 5 years ago, it likely isn't protecting you now. So you've got to amend not only your due diligence, but also your continuous monitoring and also your response plan, assuming that vendors are your weakest link, which they are in many cases.
All right, Jonathan, thank you very much for sharing all of your very valuable opinions in your realm of the world of the ecosystem of an incident commander. Again, I consider legal to be my guardian, so to speak, to make sure I don't get into trouble and I don't get my customer into trouble. And I thought it was really valuable to get some of your perspectives on these modern topics that we're running into every day today as an incident commander. So thank you, Jonathan, for participating.
Oh, my pleasure. It's been fun. Thanks.
The Incident Commander series are brought to you by Kuhn Backers.